Chair Mao and members, my name is Jill Gaulding. I'm currently the co-director of the Workers' Rights Clinic at the University of Minnesota Law School, and I am also speaking today on behalf of the other co-director, Lisa Stratton, who was unable to attend. My general background lies in anti-discrimination law, which I've taught here in the U.S. and also studied overseas in Germany and European Union. And over the years, I've also represented numerous individuals who have been seeking to enforce state and federal anti-discrimination laws. And I want to thank you for giving me the opportunity to testify today in favor of this bill. Before I begin my remarks, I actually want to comment briefly on the question that was raised about the wording of the bill. Wording of the amendment, whether we should be talking about sex equality or gender equality. I think that question of wording can certainly be settled later, but I just wanted to mention that, in my view at least, the modern understanding or the modern usage of those terms means that they're essentially interchangeable. So in other words, equality of the sexes requires gender equality and vice versa. So another way to say that same thing is, if we want to treat men and women equally, we have to treat them as individuals without imposing gender stereotypes on either sex. And so I'm going to be using both terms today somewhat interchangeably as well. As everyone has heard, and as everyone I think knows, that the effort to pass a federal ERA ran aground in 1982, which is nearly 3 decades ago, which I think fairly raises the question, why do we need a Minnesota amendment now? And I think, as you'll hear from all the testimony today, the answer to that question is as multifaceted as the problem of inequality itself. But I'm going to review 3 main reasons. Number 1, although we agree that men and women should be equal, that right is actually not legally guaranteed. Number 2, we still need to guarantee equality legally because inequality persists in many forms in our community, and it hurts all of us. And finally, I think passing an Equal Rights Amendment will reflect and reinforce Minnesota's leading role in the modern global economy. So, as to reason 1, although we agree that men and women should be equal, that right is not legally guaranteed. I think we all know that there's no such provision in our state constitution, or we wouldn't be here today. There is no state ERA yet in Minnesota. More confusing, perhaps, is what level of protection exists under the federal constitution. People know that there's a clause in the federal constitution that guarantees equal protection, and that's certainly relevant to the question of gender equality. However, I think it's fair to argue that equal protection under the federal constitution is not really equal. In order to explain that, I need to explain the difference between some technical legal terms, one of which is something called intermediate scrutiny, and one of which is called strict scrutiny. The 14th Amendment to the federal Constitution guaranteed equal protection. However, that concept of equal protection has been interpreted differently depending on the right that's at stake. So a right to be free of race discrimination, or a right that concerns other kinds of challenges to things that are considered fundamental rights, get strict scrutiny according to the court's interpretation of equal protection. And there's a legal gloss for that term, but basically what that means is we take those forms of discrimination and those rights very seriously indeed. Meanwhile, sex discrimination is treated less seriously. It gets only what the courts have called intermediate, or sort of middle-level scrutiny. Now, why is strict scrutiny a better standard? I think I can give one example just through a case that's been decided under the intermediate scrutiny standard. That case is called Nguyen. It's a federal Supreme Court case, and basically what the court decided in that case is, under the intermediate scrutiny standard, it's okay to require dads to prove that they love and care for their kids, while moms don't have to prove that. And to understand what they were specifically deciding in that case, you have to know a little bit about this story. There was a dad, a father, a U.S. citizen, who was in Vietnam, had a child there, and cared for that child from the very beginning. He acted as that child's caretaker and parent. He brought the child with him when the child was young to the U.S., and they lived here for many years. Unfortunately, the child, who was a boy, got into some trouble and actually faced deportation, and that was the question at issue in the case. And what the Supreme Court decided was, under the intermediate scrutiny standard, it was perfectly okay for this to be true. If that child's parent, the U.S. citizen, had been a mom, the child would not have been deported. But because the child's parent was a dad, the child could be deported, and in fact was deported, simply because the father hadn't jumped through a hoop when the child was very young when they moved back to the U.S. to actually officially promise on the record to love and support and care for his child. In other words, we assume that mothers are going to do that, but we don't assume that fathers are going to do that. I would argue from that case that the intermediate scrutiny standard is too weak, that equal protection isn't really equal for men and for women. It's also been argued by a lot of scholars that the standard is simply too fuzzy or inconsistent, and you can see that if you look at federal equal protection law, contrasting a case like Nguyen, which really doesn't guarantee equality. In fact, it really reinforces gender stereotypes, with a case like VMI, which was the case that in which the Supreme Court said it was not okay for a military academy to refuse to admit females as students. The basic reasoning behind that was any such exclusion of women would be based on gender stereotypes. There was no good basis for it otherwise, and therefore the ban on women students was overturned. So some people look at VMI and say, well, that's not really intermediate scrutiny, that's strict scrutiny in disguise. It's basically hard to know, that the standards are messy. I think the bottom line is that it's simply better to treat sex discrimination like race discrimination. Both types of discrimination are serious problems, and both deserve strict scrutiny. One quick example of how this can matter, in Texas, where they do have an ERA, there was a case that was very much like the federal Nguyen case that had to do with dads' rights. And in that case, they decided essentially exactly the opposite of what the federal court decided. In that case, they said dads don't have to jump through any extra hoops to prove that they deserve to be a parent. So if we have, in Minnesota, a state amendment that establishes gender equality or sex equality, we'll get that strict scrutiny standard. And I think that's consistent with what our citizens want. There's been polling, at least in the last decade or so, about what people think about equal rights and an equal rights amendment, and it shows that they, first of all, thank goodness in this day and age, agree that men and women are equal and should be treated equally under the law. They also think that our laws should express that. They should say explicitly that men and women need to be treated equally. The problem is people think that it's already there, and it's not. Maybe some of that confusion relates to this whole complexity of how we understand what equal protection really means. But I think a sophisticated understanding of the law, and you look at cases like Nguyen and you think, we're not there yet. We really do need to express this in our state constitution. And I think, as other people have pointed out, many other things are captured in the state constitution, the right to hunt and fish and to gamble. If we can spend the time and energy to put those sorts of issues into the state constitution, we certainly can place into the Constitution such a bedrock principle of justice that men and women should be treated equally. So reason number 2, going back to my 3 reasons, we still need to guarantee equality because inequality still persists in our culture, in our community. And you're going to hear a bunch of testimony today on all sorts of topics like equal opportunity, pay equity, workforce flexibility, gender fairness in the court systems, a reduction of gender violence and domestic abuse. If we want to deal with those issues, we really have to focus on the issue of equality. And admittedly, passing this Equal Rights Amendment is not going to magically eliminate any of those problems, but it does provide us with a necessary tool. At its core, I think this is a question of basic justice. Should men and women have equal rights under the law? Our answer to this question should be enshrined in the state constitution so that it can inform every single decision that our legislature and courts make. And I think to think about this in a more concrete legal way, we really need this both backwards and forwards. In the backward sense, we need this because we have made a lot of progress. We've made tremendous progress in the recent decades. But that progress can be rolled back, and we saw an example of this recently at the federal level. People were pretty shocked by a case called Ledbetter. I think everyone in this room is probably familiar with that case. In that case, the federal Supreme Court found that women have no right to sue an employer for gender discrimination in terms of their pay that's gone on for decades, merely because that gender discrimination had gone on for decades. In other words, the court basically said, it's too late for you to sue, even though each new paycheck that you get pays you less than the male employees, simply because they're men and you're women. Congress fixed that poor decision by passing the Lilly Ledbetter Fair Pay Act, but that might not have been necessary if we had enshrined in our law to begin with the idea that men and women need to be treated equally under the law. Looking forward, I think the best way to understand why we need an ERA is to recognize that questions will continually arise. There will be new questions. And I could give you lots of examples from the other states that actually have a state ERA of where the state ERA has made a difference as new questions have arisen. But in the interest of time, I just want to mention one, specifically jury selection. Do men and women have an equal right to serve on juries? Hopefully we would all say yes, they do. This is a core political right, both for the people who are accused and for those of us who would want to serve as citizen jurors. But the federal equal protection standard, under a case called Batson, doesn't fully protect that right. By contrast, we can look at a state like Illinois, which has a state ERA and has strict scrutiny under that state ERA. And in that state, you find that the right to serve on a jury is better protected, both for men and for women. We could also cite other new questions, such as those raised by new forms of medically assisted reproduction, because those raise all sorts of questions about what does it really mean to be a mom? What does it really mean to be a dad? All of those are gender equality issues. I think the bottom line is that we may not yet agree on the right answer to all sorts of questions, either existing questions or questions we haven't even thought of yet. Certainly, we may not all agree on how we should think about issues like abortion or same-sex marriage, but I do think we can at least agree that however we answer those tough questions, our answer should be consistent with gender equality. Gender equality should be a bedrock principle of Minnesota law. So finally, I want to touch briefly on reason number 3. Passing an Equal Rights Amendment will reflect and reinforce Minnesota's leading role in the modern global economy. I think you'll recognize today that the testimony you hear underscores that gender equality is an economic issue, and it's an issue we face not just in Minnesota, but everywhere. The roots of this persistent inequality lie in our attitudes about men and women, who men and women are, and what they're capable of doing. Because of this, I think it's really important for all of us to take part in a conversation about what equality really means. The legislature and the courts need this amendment for some of the reasons I've already discussed, but I think ordinary citizens need it too. We need to wrestle with these issues expressly in order to solve them effectively. And I'd like to point out, maybe in part because of my own, I have an academic background in an area called cognitive science, and so also something called cognitive bias. I'd like you to note especially the testimony you'll hear today about recent social science research into that area. What we're finding, what the scientists are finding, is that the brain works in mysterious ways, which we're only just beginning to understand. What that means is we're not done discussing gender equality. We can't let the gender equality conversation end with that 1970s or 1980s stalemate and a 1970s or 1980s level knowledge. Finally, I just want to point out exactly why passing an amendment now will demonstrate Minnesota's leadership. Like I said, we need to talk about our new understanding, the scientifically enhanced understanding of the causes of persistent discrimination. In doing so, we're going to educate the public of this state, and we're going to stand as a role model for other states, most of which also still lack a state ERA. We can also take a leading role at the national level, because there's a debate going on at the national level about a revived federal Equal Rights Amendment. And finally, we can earn the right, really earn the right to participate in the global conversation. I think people are probably familiar with the acronym CEDAW. That's the Convention on Elimination of Discrimination Against Women. If we kind of put this in layers, we have a state ERA, the federal ERA, and CEDAW is the cap to all that because it's the global level ERA, if I can oversimplify it. 185 countries have ratified CEDAW, and the United States, is not one of them. Unfortunately, what that means is it diminishes our leadership globally on questions of human rights and gender equality. So efforts on each one of these 3 levels, the state level, the national level, and the global level, they matter and they reinforce each other. So I'd like us to take this opportunity to be on the forefront of all 3 levels. Thank you again, Chairman Moe, and your staff and the members of this committee for considering this important bill.
Thank you. Any questions?